Recently, we all heard the news that Elon Musk was going to buy Twitter. Unfortunately or fortunately, the deal did not manage to pull through. The chief executive officer of Tesla attempted to back out on some rather interesting grounds. He claimed that he was not going to complete his purchase because Twitter has been misleading regulators and investors about the number of fake and spam accounts on the platform. According to him, this number is significantly higher than the 5% figure that he had initially in his mind and that Twitter has been citing for years. While this statement is true to a certain extent, the whole deal break thing did not go as Musk had exactly planned out. It was rather turned into a fierce battle involving the courts and some long trials. Right now, Musk is in deep waters for some of the baseless claims against the giant Twitter. After some official investigations, the facts that have come out are quite different from the ones that Musk provided. In May, Elon stated on Twitter that the percentage of accounts on the platform that is fake or spam could be much higher than 20%. Musk stated in the termination letter that he was withdrawing from the agreement because the percentage of bots using the platform was wildly higher than the 5% estimate that Twitter has made publicly available. Twitter had filed a lawsuit against him to compel him to carry out the acquisition, and the trial for this case is scheduled to take place in Delaware in October. During a hearing that took place on Tuesday, lawyers for Twitter stated that the day before Elon Musk sent his first letter to Twitter executives terminating his agreement to acquire the company for $44 billion, two firms were hired by Musk himself to analyze massive amounts of data relating to Twitter and report their estimates of the number of bots that are active on the site. While the company, Cyabra, estimated that there were 11% bots or fake accounts on Twitter, the other company, Counteraction, claimed that its analysis discovered only 5.3% bots. According to a lawyer for Twitter, both of Musk's chosen firms have come to conclusions that are very much in line with Twitter's claims. None of these analyses even remotely supported what Musk told the Twitter parties and told the world in the termination letter he served up.
Beyond reasonable for Twitter to claim that the number of essentially the number of said another way, the number of real unique humans that you see making comments on a daily basis on Twitter is above 95%. That is what they're claiming.
Twitter's attorney went on to accuse Musk's legal team of intentionally withholding the data during their court battle. He stated that they had not only been able to view the documents as of Tuesday, despite the fact that they had been seeking them out since the beginning of the lawsuit. According to the lawyer, if there are any analyses that exist that actually substantiate what Mr. Musk told Twitter and told the world, they certainly have not been produced in discovery in this case. But this was not all that Twitter had to accuse Musk of. Twitter's legal team claims that the reports were delivered to billionaire entrepreneur the day before he made public his intentions to back out of the merger agreement. Despite the fact that the results of both data groups appear to be supportive, Twitter has criticized the methodologies used by both groups. Twitter has filed a petition with the court requesting that an order be issued compelling Musk to disclose additional details regarding the work of multiple data scientist consultants in relation to fake accounts on the social media platform. The company stated that while Musk has shared some details produced by its consultants, he has also engaged in a pattern of delay and obstruction over the past 2 months. Musk's lawyers denied the claim that their client had engaged in such behavior. Separately, Twitter accused Musk's team of failing to hand over relevant signal messages and denied that Musk used the encrypted messaging app, citing evidence of an exchange with an investor, Mark Andreessen, in April in which messages were automatically deleted after a period of time. The evidence was based on the fact that messages were automatically deleted after a certain amount of time. The conversation was also brought to light after Andreessen emailed a screenshot of it to himself and several other people. Twitter also claimed that Musk's legal team had failed to turn over text messages prior to the trial that was exchanged between Musk and James Gorman, chief executive officer of Morgan Stanley, and Larry Ellison, chief executive officer of Oracle. To this, Musk attorneys refuted any allegations that their client had intentionally withheld communications. Lastly, Twitter also filed another petition with the court asking for sanctions to be imposed on Musk for his improper behavior regarding the failure to produce the messages. This included a finding known as an adverse interference, which gave the court permission to assume that Musk was hiding details that would undermine his legal argument. While this could have certainly meant more trouble for the billionaire, the Chancellor of the Delaware Court of Chancery, Kathleen McCormick, did not make a decision right away and instead stated that she would consider the matters and make a decision later. The trial is scheduled to start on the 17th of October and will last for 5 days. All this just one side of the coin. Now let's see what Musk has to say. The fact that 11% of Twitter users are still considered to be bots, which is significantly higher than Twitter's own estimates, could turn the situation in Musk's favor and make the whole trial much more dangerous for Twitter. Musk's primary argument for pulling out of the deal was centered on his claims that Twitter intentionally misled him, investors, and the general public about the number of authentic accounts on its platform. Authentic accounts are defined as accounts that are operated by a single human user. Musk asserts that this constitutes fraud, which enables him to back out of the acquisition without incurring any costs. The billionaire made the change to his countersuit against Twitter at the beginning of the month, adding new claims that are based on the whistleblower disclosure made by Peter Mudge Zatko, a former security chief at the social media company. During his year working at Twitter, Zatko worked on a number of projects, including one in which he was involved in the development of a new product. Twitter has stated that it investigated and addressed all of Zatko's claims when he raised them during his year working at the company, and it is now looking for any connection between Zatko and Musk or his advisors. The new allegations made on Twitter by the world's richest man also include the assertions that Twitter has not complied with a consent decree reached with the FTC in 2011 regarding its data security. He also asserted that the company does not hold the appropriate intellectual property licenses for some significant machine learning work that it's conducting. Both of these allegations are pretty serious and included in the new class action lawsuit. Musk has recently stated that due to these issues, he is now able to withdraw from the transaction completely. Experts in the law are not persuaded that any of Musk's claims are compelling enough to win this case on their own. However, anything is possible, and we cannot make any judgments as of now. Despite the fact that there is ongoing speculation that the parties might be able to reach an agreement outside of court, the case is still going to be tried for a total of 5 days when it officially begins. Well, this brings us to the end of this video. If you liked the video, please consider subscribing and sharing so we can keep bringing you more content like this. Also, let us know in the comments your thoughts, and we'll see you next time.